Can you sue the government in Florida for a car accident or another type of negligence claim? The answer is yes, you can. You can sue whether it's a city, a police department, a county, school board. You can bring a claim against these entities. They're called sovereign entities, right? So this goes back to the time when you couldn't sue the king. The king was called the sovereign, and he had sovereign immunity. He was immune from being a lawsuit being filed against him. So the entities in Florida that operate under the state and municipalities and government agencies, essentially, they enjoy sovereign immunity. However, in Florida, they've given a limited waiver of sovereign immunity. That means you can sue them for certain things, but it's subject to limitations. So in Florida, when you sue a sovereign entity, the attorney's fees are capped at 25%. So normally our fees are a third before a lawsuit and 40% in a lawsuit, but with a government agency under the state of Florida, that is capped at 25% across the board. If it's a federal agency, in the pre-suit process, it's capped at, before you file a lawsuit, it's capped even lower at 20% of attorney's fees. Now, the reasons that they do this are to discourage cases against the government, right? Because if attorneys are going to make less money on that case, they may be a little bit less likely to sue the government. We still take those claims at Carter Injury Law, but we're a little bit more selective about those cases. But we will certainly give anybody a free case evaluation that calls us with a case against a government agency. The government agencies are a little bit harder to deal with. They don't have the same regulations that insurance companies have because they're not insurance companies. So insurance companies have an obligation to protect their insureds, whereas somebody who is working as a risk manager for a city, for example, doesn't have those obligations to the city of Tampa. They work for the city of Tampa, but they can take longer to respond to settlement negotiations. They can kind of delay the process a little bit more if they want to. They usually aren't gonna offer as much as an insurance company is because they aren't as scared about fighting things in court. Or scared's probably the wrong word, but they're not as hesitant to spend the money on attorney's fees because they have some in-house city attorney who might fight it for them. The other thing is the claims are capped at $200,000 per occurrence, $300,000. $300,000 per occurrence, $200,000 per person. So the most that you can get as an individual in your claim is going to be $200,000. And this is, I'm not talking broadly here about other people making claims and consortium claims and estate claims and wrongful deaths, but just you get rear-ended and you're alone in your car, you get rear-ended by, say, a city truck, you're going to be limited to $200,000. That goes all the way from the beginning of the case to the end of the case. So even at trial. So sometimes with insurance companies, we can get our attorney's fees paid by the insurance company if we settle or if we file what's called a proposal for settlement and they don't take it. When you're dealing with a city, even if the jury gives you $300,000 and you beat your proposal for settlement, so they would owe you, let's say, $100,000 of attorney's fees on top of that, all that's going to get reduced down to is $200,000 that they have to pay you. So it's always limited to that. The exception to that is what's called a claims bill. So if you want to get more than that, you have to file a claims bill. The legislature essentially has to approve it in order for you to get more than $200,000. That is a whole different conversation and a long road that hopefully you don't have to go down. But it's a very unfair process. It's very, in my opinion, it's very unfair that we can't sue the government for as much money as the damages that they've caused you. You also can't sue the actual what's called the tortfeasor. So the person, you can only sue the agency. So the person who caused the accident, you don't get to sue them. Like, let's say it's a bus driver, right? For example, they rear end you. You don't sue the school bus driver. They have immunity from being sued because they were acting within the course of their and scope of their employment with a government agency. You have to sue the actual government agency, and then the government agency has all these protections that limit your recovery. So is it fair? No. Do we know how to deal with the claims? Yes. Will we take your call and talk you through the process and help you out if we can? Absolutely. So if you've been involved in a personal injury claim or a car accident claim or any kind of claim with a government agency, it's very important that you proceed the right way. The other thing to remember is that they get 6 months to dispose of the claim. So we need to send them a certified letter, and there's a statute 768 that lays out everything that we have to give them, right? We have to put in a letter, certain information, identifying information about you and your case in order to meet that statute, to put them on notice, right? So we send them a certified letter. Now we have proof that they're on notice of it. 6 months have to go by before you can sue them. So there's a 2-year statute of limitations and you have to wait 6 months. So you really see how you kind of have to thread this needle. It's got to be more than at least 6 months, and probably you're not going to get that letter out to them on day 3, right? So if you wait 6 months, now they get another 6 months. So it's important to get an attorney on board as soon as possible, or to start handling the claim yourself as soon as possible, and making sure you follow every little thing, because if you don't follow every little thing, they're going to move to dismiss your case out of court. So dealing with government agencies is very tough, but we do it. Call us today for a free consultation, and we will walk you through the process.